Hello, everybody. I'm Andrew McKenzie, and I'm here with my colleague Bill Kessler. And we are here to present you with the next in our series of webinars. We're going to be talking about adjusting property boundaries and what your options are. And you could sort of call this a talk about friendly quiet title, but that's really only one of the topics that we will be covering. So, a lot of people own property, and there can be a lot of reasons why you might be interested in modifying your property boundary. Bill, can you tell people what some of those reasons would typically be?
Sure. So whether you've got residential property or you've got commercial property, you might want to move the boundary line around, and your neighbor might want to as well. So there are scenarios in which there's where you've got a dispute about the property line, where you and your neighbor are someone's raised an issue and you don't have a resolution yet, and you may litigate that. We're not really focusing on that as much in this webinar. We're focused mostly on the what we're going to call the friendly quiet title, and then other alternatives to it. So why might you want to adjust a boundary line? Again, certainly that litigation scenario, but we'll focus on more of the agreed scenario. So one might be to maximize what they'd call the highest and best use of the property. So for example, if you had a little bit more land, you might be able to short plat that property, meaning get more than one tax parcel out of an existing single tax parcel, and then develop that property. This is a classic example is a big residential lot that could be split in two and another house put on it, but sometimes
So,
it's
so
more than
take
that.
a so take a hypothetical. Let's say you and I each owned an acre and a half, and we were both in a zone where it was one dwelling unit per acre or something like that.
Right.
If we each stayed with 1.5 acres, we'd both be stuck with what we've got. There'd be no way of building an additional unit on there. But if I reached an agreement with you where I was able to take, say, half of an acre from you, now I've got a 2 acre parcel. I could possibly apply for a short plat to split my parcel in two and get an extra house on there that I might be able to develop and sell, right?
Yeah, that's right. And maybe you pay me a few bucks. Obviously, you'd pay me some money, but it's mutually beneficial to both of us because I might lose half an acre in that example, and it's not really a very big deal to me. Let's say it's some yard that I don't really care about that much anyway. So that's a good example. Another could be mutual benefit to which so in Andrew's example, it was just it was just a benefit to Andrew, and then the benefit to me was his payment. But sometimes if you tweak boundary lines, you can have mutual benefit. So um, I had a client who had a big yard, and they were two older people and they didn't really care about their giant yard. They just had to mow it. But the next door neighbor had a couple little kids and had like no yard at all. And so we were able to move the boundary line via this friendly quiet title method.
Right.
Uh, that we'll get into. So that was mutually beneficial. My neighbor lost yard he didn't really want anyway and got paid for it, of course. And then the other neighbor gained yard that he did want for his kids. You could also have topographical issues. Andrew and I were discussing that, and you could have an unnatural parcel where there's an unusable portion for one neighbor because it's too high or too low height wise, and it'd be more even if you adjusted the boundary line so you could swap land around.
Right.
Um, you can also cure a nonconformity. So Andrew had mentioned uh, zoning and being able to, depending on how big that property is, you could or how small it is, you might be able to short plat it. Well, sometimes it's if the parcel is actually too small, you've got what the city planners would call a nonconformity. So there you can't get a permit to do the sort of remodeling that you want to do because you might have a maximum lot coverage issue, meaning you've got too much impervious surface covered for zoning restrictions, or you might have a setback issue where your house is too close to the record line, and so you can't get a permit. So you can cure that by nudging boundary lines around too. And then the classic example is matching the both neighbors' use to the record line. So you've got fences that have been there a very long time, and a survey reveals that, and the both parties decide that they want to make, for example, a fence line be the record line, even when the record line is a little bit off of the fence line. So these are all examples of cases in which you'd want to adjust a boundary line.
Here's another thing to mention too. A lot of our clients come to us with adverse possession related matters. And the law technically is that once you've satisfied the requirements for adverse possession, you in fact become the owner of the property that you have adversely possessed. Why is that not good enough? If you want to develop your property or put new improvements on it, why can't you just treat the new property line that where you've adversely possessed as the setback?
Right. Good question. So that's because it's not a matter of county record. It's not a matter of government record. So between you and the neighbor, you both might know that adjustment has happened, but the rest of the world doesn't know it. And so to make it a practical, usable acquisition of title, then you've got to go through an adjustment.
Right. So those counties and cities that have jurisdiction over your ability to build, they are not going to just take your word for it that you have adversely possessed a specific area of property.
Right.
They want to see something that is a matter of public record so that they don't get themselves in hot water with a dispute down the road.
Right.
So, okay, well, let's turn to our next topic, which is the different ways that you can go about adjusting boundary lines. And we're going to talk about some of the pluses and minuses of each of those options. The most traditional way of doing a boundary line adjustment would be what?
You typically adjust a boundary line through a process that through the city, if you're in city limits, or through the county, if you're outside, and that's called typically a boundary line adjustment is the actual statutory name of the process. So I'll talk about some of the pluses and minuses here. And in fact, let me share my screen here. Okay. Kind of maximize this. Andrew, can you see it?
I can see it.
Okay. So you've got a traditional boundary line adjustment. And the downside, there's mainly downsides to it. So the boundary line adjustment is where you go through the county, you make an application just over the counter through the counties or the city, like in the city of Edmonds Planning and Development Department. You'd make this application, and what you're doing is you're saying, city, please adjust the boundary line. And so they charge you a fee, they take whatever time they take, and then at the end of the day, they either grant your boundary line adjustment or they don't. So the length of time is a downside. The cost, we'll talk about the cost of a friendly quiet title, but it's usually ballpark the same, as it's not appreciably different than a regular boundary line adjustment. But the real big problem with the boundary line adjustment is the lack of certainty. So you can go down the road and you could be months into it, and they can the city or county can just deny your application for a boundary line adjustment. They don't have to give it to you. There can be any number of problems with the application, and you don't need to dive into those problems or cure those or determine what all those problems are, because the friendly quiet title is a way around it. But if you do the boundary line adjustment, you need to know that you're going to get it. And even if you think you know you're going to get it and you think it's clean, something can crop up and they don't have to give it to you.
Right.
Certainly if you're going to create a non-conforming lot, you cannot create a non-conforming lot with a boundary line adjustment. And
That's right.
So if you want to be creative, the boundary line adjustment through the city or the county is not the way to go.
That's right. So the city or county bureaucrats who are reviewing your application for that boundary adjustment, they're going to be applying the local codes that are applicable, and they might not like what you're trying to do,
Right.
and they have sway to tell you no.
You're right.
Um,
Right. Yeah.
so there is a statute in Washington that allows property owners to simply agree to adjust the boundary. What's that statute all about?
So you'll see it on the outline here, RCW 5.84.007, what I call the 007 agreement. It looks really great on its face. It says if you've got a dispute about a boundary line, so you get a survey, you realize that you say, for example, a fence is encroaching or a mow line is encroaching, a shed is encroaching, something, whatever it is, and you decide to settle that dispute. It gives you a statutory process for getting a record of survey, and so you get your survey work done, and you then adjust the line in theory in whatever way you want. And it looks on its face like a pretty slick way outside of the city's boundary line adjustment to adjust your line. But there are lots of problems. There are definitely problems with the boundary line adjustment process that you go through with the city or county. There are many more practical problems with the 007 agreement. As a practical matter, the 007 agreement just shouldn't be used at all. The boundary line adjustment usually shouldn't be used. There are certain scenarios when you can. The 007 agreement should just be disregarded.
So the 007 agreement, as we've termed it, has some advantages. One advantage is that you don't have to involve the city or the county.
Correct.
You don't want to. You can just enter into an agreement. There's no litigation that's involved, and the boundary is by statute adjusted once the agreement and an appropriate survey are recorded. But there are some practical problems. One is that title companies are not always willing to insure title to property that has been adjusted in this way. There seems to be a divergence in local practice in terms of where title companies or which title companies would be willing to bless an agreement like this and consider the agreement conclusive on the issue of title. There is an Attorney General opinion that came out in 2005 from the Washington State Attorney General's office. It's an advisory opinion, so it's not binding in terms of the interpretation of the statute. But one possible issue that you could be facing if you decided to go this route is that it appears from this Attorney General's opinion that the Attorney General is interpreting the statute as applying only to situations where the deeded property line cannot be ascertained, such as if you've got a monument from decades ago that was lost or that got moved, or a surveyor, a professional surveyor, somehow lacks the ability to come in and with certainty say, this is the line. In other words, under this narrower interpretation of the statute, which I personally disagree with, under this narrower interpretation, the statute would not apply to allow neighbors to voluntarily adjust their boundaries in run-of-the-mill situations where they just want to reach an agreement, but there is not genuine uncertainty about where the deeded line is. So that may be one reason why title companies are reluctant to insure title when this type of agreement is used. My own personal opinion is that it would be extremely beneficial for a reported court case to come out and clarify the scope of this statute and to say that it means what I personally think it means, that could make it a more feasible option in the future. But for the time being, we live with this degree of uncertainty, which is probably a good reason for choosing a different option for adjusting your boundary.
Yeah, it's and I'll take it one step further. The 007 agreement isn't just disfavored by title companies. They will not insure title when a 007 agreement's used to move the boundary. And I've heard that, I, I have heard that from every single title examiner I've ever spoken with. I believe we are joined today by a title examiner, and if I'm looking at my, or a former one, so I'll be interested in his opinion on this. But I have had clients, I had counsel on the other side tell me that we're going to adjust the boundary line through the 007 agreement. I said, no, I've had it. I've had multiple examiners tell me that they won't insure title. He said, no, my title company will do it. A particular unnamed title company, they will do it for me. And the gal I know there, she has no problem with it. And I've run it by her already. Oh, okay. So we got down the road and spent several $1,000s putting this thing together, and had a very clean, pretty 007 agreement. And she refused to, at the end, she ran it up the flagpole, and title counsel said no, they wouldn't insure. So because there are other options, and most importantly, the friendly quiet title, what we'll be talking about, the either a boundary line adjustment or a friendly quiet title is far preferable to a 007 agreement, and the friendly quiet title is usually preferable to the boundary line. We'll get to that.
Okay.
But in general, I would just disregard the 007 agreement. I agree with Andrew that it would be great if there was a case that would come out and clarify that and give title companies a little bit more comfort. But
so we're now going to talk about friendly quiet title, which you could say has two components. There's the friendly part, which might sound like an oxymoron to some of us, and there's the quiet title part. Probably a lot of our audience does not know what quiet title means. So in order to not lose people, it might be helpful to explain that a little. Quiet title is the process of getting the public record to reflect and confirm what people's title interests in property actually are in the face of either a dispute or uncertainty. You could sort of think of it as when there's a dispute over title, people make a lot of noise, and we call it quiet title, or at least I think of it this way. We call it quiet title because we're quieting all of the noise by putting an end to a dispute or uncertainty, and laying down the law and saying, this is what is owned by whom. So that's why we call it quiet title, as far as I'm concerned. It is generally in the form of a lawsuit. And so a lawsuit is actually a way that you can adjust your property boundaries. Do lawsuits always have to be adversarial, Bill?
Yeah. So no, you've got to have a dispute, of course, but your dispute does not. You don't have to know about your dispute before you know about your desire to move the boundary line. So very frequently there are encroachments. That's your most common reason to need a quiet title, and certainly in the context of moving boundary lines. Whether it's high density commercial, whether it's sort of low density residential, there are typically encroachments in the form of fences that are running on one side or the other of the boundary. Maybe it's only several inches, maybe it's several feet, maybe it's one neighbor's use of a piece of property that, unbeknownst to everyone until they get a survey, and that's the big deal, is a survey. Before they get the survey, everyone doesn't understand that there's an encroachment, but once they get it, it inevitably reveals encroachments. So, well, I shouldn't say inevitably, but every time I've seen, there are encroachments. So there's this method of resolving an encroachment called a lawsuit for quiet title that Andrew mentioned. And so one side or the other is going to have a claim for either adverse possession or prescriptive easement, or if you're the one getting encroached upon, a lawsuit for ejectment. We don't need to go down that rabbit hole, but there are very various different ways to claim that, hey, that property's mine, or get off my property. And that's what you claim in the quiet title lawsuit. And whether it is agreed or not agreed, that's how the lawsuit's structured. And we'll get into the procedure of it here, as you can see. But the idea is you come to an agreement with your neighbor about how a lawsuit's settled. And once you have an encroachment, once you realize that there is a dispute about the title, hey, this fence line is off, you're encroaching or I'm encroaching. How long has your use been? Has it met the elements of adverse possession? And you can Google that, and you can go on our website and look at some of the blog posts about adverse possession. But that's where the dispute comes from. And then you settle that dispute however you want, adjusting that boundary line however you want, because it's nobody's business but you and your neighbor how you're going to settle a dispute that comes to that how you and your neighbor are going to resolve that dispute, regardless of how big or small the encroachment is. So that's how you do it. That's not how you do it. It's the structure of a friendly quiet title. It's a lawsuit, but it is settled as soon as it is filed. And so, Andrew, I could get into the procedure. Before I get into the procedure, is anything else you want to talk about of the 35,000 feet on the friendly quiet title?
Well, before we get to procedure, just to note some of the benefits of doing this. Similar to the 007 agreement that we talked about earlier, the huge benefit here is that you do not have to have the blessing of a city or a county.
Yes.
What you wind up with at the end of the day is an order from a court that is enforceable, that determines who owns what and where that boundary line actually is. And there is no requirement, statutory or otherwise, that the resulting parcels at the end of the day be conforming lots. So for example, suppose you live in a city where the minimum lot size is 10,000 square feet. You and your neighbor on paper each have a 10,000 square foot parcel, but their fence is 5 feet onto your property, and they have adversely possessed that 5-foot strip for the last 20 years. If you go through this process of friendly quiet title, you might end up with less than a 10,000 square foot lot, which is the minimum for your zoning. But the mere fact that you're now in a non-conforming lot, the city cannot veto this boundary line agreement or this friendly quiet title order on account of the resulting non-conformity. So Bill, you want to talk about the procedure a little bit more here?
Right. So, and to put a cap on that, for exactly the reasons that Andrew just said, the friendly quiet title is in many circumstances far more preferable than the boundary line adjustment process through the city or the county, and certainly preferable to the 007 agreement. Because you get, and I'll repeat what he said because it's really important, you get an order from a judge, and the judge's order says, here were our old legal descriptions, and now here are our new legal descriptions, and these two tax parcels are now hereby adjusted to be these two new legal descriptions. And the judge says hereby, and that's adjusted. Those boundary lines are adjusted by the judge's signature. And then you can take that order that gets entered with the court, and you record a copy of it with the county, and that's it. The city and the county don't have anything to, their building departments or whatever are not going to, I suppose they could intervene in the litigation, and I've never heard of that happening. Not that they'd have notice, but so that would take precedent. The judge's signature would take precedent over a county or city bureaucrat signing a boundary line adjustment. So the procedure, of course, you negotiate it just like you would in the case of a boundary line adjustment. You and your neighbor negotiate how this is going to be resolved. You've got a settlement agreement. So you enter into a settlement agreement. And then ideally, you determine where the encroachments were first. You need a survey to do that, but you don't want to really incur the costs of the survey if you can avoid it until you've got the settlement agreement. I suppose in an academic world, not a real world, but a purely academic world, you could have this whole negotiation done, get a survey, and realize that there's no fence that's even a millimeter off. There's no encroachment whatsoever. That's possible, but there could be other types of. Actually, it's not really possible. It's very, very unlikely. So you've got the negotiation. You then draft up your settlement agreement. Not you, the lawyers. Draft the settlement agreement. Draft the court documents. The survey then lays out here's what the old legal descriptions are. We know that. The survey describes the encroachment. The survey then describes what the surveyor generates legal descriptions for the new lots, the 2 new lots, or more than 2 lots. Then we take the surveyor's new lots, we insert them into the court order. Again, the court order saying, here's the legal of the previous, here's the sliver of encroachment, here's what the new lots look like now. Boom, judge signs it. We present that order along with the rest of the lawsuit, the documents necessary to commence the lawsuit. We present all of that to the court, file it with the court, present the order, judge signs the order. That's it. And again, once the judge signs the order and you record that with the county auditor's office, that's just like a deed. It's the equivalent of a deed. It's the equivalent of boundary line adjustment, and the boundary is moved that way. It's much faster and more certain than the boundary line adjustment process. Sometimes I've seen special circumstances. So sometimes people say, well, how do I do that when I own both parcels? You can't sue yourself. But what you can do is you can recognize the encroachment that's going to happen. So as soon as you sell, if you're interested in selling. So what we've done this several times, and we build the quiet title into the purchase and sale agreement, so that once you have diversity of title, the second that sale closes, you've now got diversity of title, and you can have a dispute. Well, if you close that sale with an existing encroachment, now you can immediately settle it. So if all of that friendly quiet title settlement is baked into the purchase and sale, that's a way to do it as well. Andrew, anything to add there?
No, I don't think so. I mean, in the conclusion is that you have options for adjusting a boundary line. You have there are many reasons why you may want to do that, and if you're contemplating that possibility, or contemplating a dispute over that property line, reaching out to an experienced real property lawyer is one of your first important moves.
And here we purport to be exactly that. Yeah.
What a coincidence.
What amazing. Well, would be glad to help anybody with this. Again, Andrew and I have been around this block many times, and this is a swift and efficient way, and most importantly, a certain way of adjusting the lines. Questions, feel free to email or call us.
Thank you.
Okay. Thank you, everyone.